The U.S. Supreme Court ruling two major issues in the past week, and how are they going to impact Illinois when it comes to the state's gun and magazine ban? Welcome in, Bishop on Air. I'm Greg Bishop. Thanks for hanging out. Like, subscribe, hit that notification bell. And let's get on into it. When I was off this past week, the U.S. Supreme Court had a busy week of releasing all kinds of rulings. There's still a stack of rulings they have yet to release, including on presidential immunity. And it looks like Wednesday they're going to be releasing those cases. If you look at the U.S. Supreme Court's website, you've got the 26th being non-argument day, where they're going to release some things. But today, in just about 20 minutes or so, they're going to release the order list. And it looks like it may be the last day they release order lists. And we could see Illinois' gun ban challenge decided one way or the other, if they're going to take it and hear oral arguments, or if they're going to say it's not ripe yet and we need to ultimately go the other way. So stay with us. Of course, if you're watching the live stream, we'll kick that on just after 8:30 to review the latest in the orders list. But the cases dealing with bump stocks, the cases dealing with the issue of domestic violence orders of protection, those were decided. The Cargill case having a outcome where you have the U.S. Supreme Court essentially saying, hey, the administrative states cannot unilaterally change various measures within statutes to ban certain types of items like bump stocks. Of course, this all came after, during the Trump administration, there was that mass shooting that happened in Las Vegas where 60 people were killed, and the firearm that was used allegedly had a bump stock. And the bump stock helps increase the rate of fire for a semi-automatic firearm, and the ATF went through and changed the definition and ultimately outlawed bump stocks, and that was challenged in court. And you have the order coming out in a 6-3 decision that ultimately led to the bump stock ban being overturned. Here's Michael Cargill talking about this on X when he announced that he indeed was victorious.
Breaking news. I did it. Michael Cargill versus Merrick Garland. The Department of Justice, Alcohol, Tobacco, and Firearms, the bump stock lawsuit. I beat him in the United States Supreme Court. I was told over 5 years ago, why are you going down this road? No one cares about bump stocks. Let's go ahead and let them take the bump stock. But instead, I stood and fought. And because of this, the bump stock case is going to be the case that saves everything. It's going to stop the ATF from coming after their brace, the triggers, all different parts and pieces that they're trying to ban. And I'm glad I stood up and fought. So now we have a case that is case law that we can move forward around this country and defend our Second Amendment rights. As always, more guns equals less crime. You go out there and you buy yourself a gun. Better yet, get yourself a bump stock.
So again, Cargill talking about his victory in this case. And the ruling really seemed to just target the issue of regulatory agencies changing law. Governor J.B. Pritzker was asked about this last week, and he said that, this wasn't a Second Amendment case. Here's the governor during an unrelated event last week.
I don't think this has any bearing at all on that, and that's why I pointed out that this is not a Second Amendment ruling. It's really a ruling about the regulatory authority of the ATF.
But the governor also asked further about this, and if Illinois needs to take any further action concerning bump stocks. If the national bump stock ban is overturned, what about Illinois' bump stock ban?
I'm not sure what those precautions might be. I mean, we certainly have made sure that we're addressing many of the major issues that we're facing in terms of people who shouldn't have weapons, obtaining them, trying to make sure that we're taking weapons away from people who have weapons now who shouldn't have them. As you know, we also, in addition to banning bump stocks, we also banned switches, which turn a regular gun or a semi-automatic gun, either one, into essentially a machine gun, just like a bump stock does for a semi-automatic weapon. We've banned those. And we, of course, took action. One of the 11 states in the country now that has a ban on assault weapons. And frankly, if you look at the numbers of crimes that have been committed with an assault type weapon in Illinois anyway, they've gone down. So that's the goal ultimately, right? We want to make sure that people have lawful ownership of a gun if they have one, and that people who shouldn't have them don't get them, and that the guns that are available are ones that meet the requirements of, not being machine gun-like and not being a real danger to the public, but rather for self-defense or for hunting.
So the governor talking about the ban on semi-automatic firearms that's currently being challenged in the Southern District of Illinois federal court, but also a question of whether or not the U.S. Supreme Court's going to take up that challenge on a preliminary basis, which we could find that out in about 12 minutes from now if you're watching this live. But, the ban on semi-automatic firearms, part of the arguments are that these are commonly owned firearms. And this is something that I think the Cargill case, 6-3 in the ruling, but the dissent had something interesting here that Gun Owners of America pointed out. Justice Sotomayor and Kagan and Jackson, Gun Owners of America says, just accidentally admitted that AR-15s are in common use because they are commonly available. This was in their dissent in Garland v. Cargill. So you click through and you see the image here, and it ultimately shows that indeed they said that they affix bump stocks to, quote, commonly available semi-automatic rifles. And that's coming from even the dissent in this case could mean you'll likely see some kind of brief filed in the cases challenging Illinois' gun ban or other gun bans across the country, saying, look, even the dissenting justices in the Cargill case recognize that semi-automatic firearms are commonly available, or as others may interpret that, as in common use. Because the argument that's being made is, well, these are military-style firearms and should not be allowed, but you've got the common use argument, and that could play into this. So interesting to see that, but clearly you've got both sides of the Cargill case sounding off. Chuck Michel said, big win in SCOTUS. In the Cargill case, ATF cannot reinterpret a statute, change its previous opinion that folks relied on legal possession of bump stocks, and change its mind to reclassify bump stocks as illegal machine guns. You've got others, Everytown, gun control group, saying that the Supreme Court just struck down the federal ban on bump stocks, deadly devices that effectively convert assault weapons into machine guns, they say. In Garland v. Cargill, bump stocks were used to kill 60 people and wound at least 411 more in our country's deadliest mass shooting in Las Vegas in 2017. So both sides sounding off on the outcome here, including the National Rifle Association, which supported the bump stock ban. And they say that the Supreme Court's properly reinstated executive branch agencies restrained them to their role of enforcing and not making the law. This decision will be pivotal to NRA's future challenges of ATF regulations. So again, just some of the back and forth here on this particular issue. But the Cargill case with the bump stocks, not the only case that the U.S. Supreme Court decided on. They also decided on the Rahimi case. And that was an 8-1 decision, essentially saying that domestic violence suspects can be restrained from owning firearms. While the majority opinion seemed to double down on the Bruin and Heller opinions about going back to the text, history, and tradition of firearms regulations, saying that if it doesn't match what historically during the founding era they had in place, then it can't be a law that can rush against the Second Amendment to the U.S. Constitution, the right to keep and bear arms. But the 8-1 decision in Rahimi, which, I mean, the background of that case, you got a person who has violent tendencies being caught with a firearm and shouldn't have had the firearm per a restraining order. The Supreme Court essentially said, you can block people who have domestic violence orders of protection from having a firearm. So kind of, While it reinforced the Heller and Bruin decisions, it essentially sided with the government saying that you can't have somebody who has domestic violence orders of protection against them have a firearm. And that quickly prompted those in Illinois to say they need to have Karina's bill passed. State Representative Maura Hirschauer posted, SCOTUS ruled that abusers who pose a credible threat to their partners and families can be disarmed under the Second Amendment, shining a light on the deadly intersection of firearms and intimate partner violence. Here in Illinois, we have more to do. We must pass Karina's bill now. So Karina's bill was a measure that did not ultimately advance during spring session. And you've got Hirschauer again posting on X, SCOTUS recognizing the deadly intersection of firearm violence and domestic violence. This decision will keep domestic violence survivors and their families safe. We can do better here in Illinois and ensure that firearms are removed from abusers by passing Karina's bill. Lives depend on it, she said. So, again, what does Karina's bill do that is not already state law? Illinois does have red flag laws, but essentially it's to where if you are the subject of a domestic order of protection, you have to relinquish your firearms to somebody who is eligible to take those firearms. Of course, we have the firearm owner ID card in Illinois, so you have to be able to hand it off to somebody else who has a firearm owner ID. Could be a cousin, could be a brother across town, that type of thing. What Karina's bill would do, it says if a domestic violence order of protection is issued, then the court must issue a warrant to go after those firearms, and police must confiscate those firearms. So you could see the difference there, right? So you've got the question of whether or not law enforcement are going to be tasked with having to follow through with warrants to go and confiscate firearms from individuals who have orders of protection against them. So obviously something that we'll hear a lot more about. The legislature in Illinois comes back for fall veto session in November. And it's very possible that this could be one of those measures that they pick up and advance. So we'll be watching that, of course, here with Bishop on Air. Greatly appreciate you guys being here each and every weekday morning. Like, subscribe, hit that notification bell, and join us with Bishop on Air.